Hello everyone and welcome to today's Mondac webinar in association with Dylan Eustace. Our expert panel will provide you with practical and current information on the insolvency and restructuring regimes in Ireland and the Cayman Islands. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Jamie Enser is a partner who leads Dylan Eustace Restructuring and Insolvency Practice in Dublin. He acts for insolvency practitioners, creditors, companies, shareholders and directors in all aspects of restructuring and insolvency, including examinerships, Part 9 schemes of arrangements, receiverships and liquidations. He has extensive experience in complex litigation before the Irish Superior Court arising from these restructuring or insolvency mandates. Niall Dodd is counsel in the litigation and insolvency team in the Cayman Islands, specialising in commercial disputes, complex, high-value, cross-border litigation, insolvency and restructuring. He advises directors, office holders, financial institutions, creditors and other stakeholders in a broad range of contentious and non-contentious matters. But before we begin today's webinar, a quick housekeeping item. You are able to submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many of those questions as possible during our Q&A at the end. It's now my pleasure to hand you over to Jamie and Niall to begin. Thank you.
Thanks, Dan. Good day, everyone. I suppose firstly, conscious that today's audience are from probably further afield than just Ireland or Cayman or even the UK or the US. So when giving some thought about how my part of today's webinar, which looks at recent themes in restructuring and insolvency from an Irish perspective, might be of the widest interest and relevance to those joining today, I suppose given the short time I have, I'm going to focus on developments within the last 3 to 4 years relevant to the consideration of Ireland and the Irish courts as a jurisdiction for restructuring, and specifically probably as a possible alternative to the English courts. Specifically, I'm going to look at kind of what companies can be restructured under Ireland's corporate restructuring regimes, considerations with respect to outward recognition of those processes in the EU, UK, US, and even in some cases jurisdictions even further afield. The UK, of course, no longer being in the EU, and so it's insolvency proceedings that previously would have come within the ambit of the recast European insolvency regulations no longer benefit from the automatic reciprocal recognition within the EU as used to be the case. And then to wrap up, I'll give an example of a recent case that might be of interest if you have clients that have obtained judgment outside the EU, and where the judgment debtor need not necessarily be an Irish company, but where there are assets in Ireland against which your clients may want to freeze and or maybe enforce against. I know that many of today's audience will be reasonably familiar with Ireland's restructuring processes, but for those that may not be, what I'll be speaking about really is examinership and schemes of arrangement. And I guess I'm aware of having a clutter table is typically not a recommended presentation aid, but in the limited time available to me today, I think it's probably a useful reference tool. And I've included what at a high level are the main common and differing features in comparison with Chapter 11 in the US and the English restructuring plan introduced in June 2020 by the UK's Corporate Insolvency and Governance Act, which would be, I suppose, the closest English comparative process to examinership. And examinership's been on our statute book since 1990. It's our primary statutory restructuring process for companies in financial difficulty. It's a debtor in possession process that has much of the flexibility of Chapter 11, but it has to work to a much tighter timeline to conclude the restructuring. So an examiner only has effectively 100 days to report to the court that a rescue plan has been put together and that the examiner has achieved the required creditor or shareholder support. And examinership is listed in Annex A to the European Insolvency Regulations as being insolvency proceedings under those regulations. And the second statutory process, which I don't have a table for, are schemes of arrangement. sometimes referred to as Part 9 schemes in Ireland, which is a reference to that part of our Companies Act which enacts the process. And it's a process that has been on our statutory books actually longer than the examinership. It was established upon enactment of Ireland's original Companies Act going back to 1963. And like in the UK, companies can use Irish schemes to implement a variety of arrangements between a company and its creditors or members. And because there's no requirement that the scheme company is necessarily insolvent, it's not a process that comes within the scope of the European Insolvency Regulation. And I'll come back to that in a few slides' time. So turning to what are the criteria for whether the Irish courts have jurisdiction to place a company into examinership, whether that be the petitioning company itself or a related company. So examinership allows for a related company to also be put under the protection of the Irish court, where the restructurer requires that a related company also be restructured or protected from creditors, if to do so would facilitate the reasonable prospect of survival as a going concern of a whole of a part of the petitioning company's undertaking. So in terms of jurisdiction, examinership is available to a company that has its COMI or its establishment in Ireland, is an Irish incorporated company, but that may have its COMI outside of the EU, or, as I mentioned, a related company to the petitioning company, and where that related company has a sufficient connection to Ireland. So just to look briefly at each in turn, so companies that have their COMI or establishment in Ireland. So the first time that the Irish courts had to consider whether they had jurisdiction to appoint an examiner to a company that was incorporated outside of the EU, but on the basis that it was asserting its COMI was nonetheless in Ireland, was reasonably recently seen in July 2023 in the Mac Interiors case that I have cited on the slide. So Mac Interiors was a company that was incorporated and had its registered office in Northern Ireland, so within the EU and within the UK, but outside of the EU. And I suppose as a foreign incorporated company, Mac Interiors didn't come within the definition of company for the purposes of the Irish Companies Act 2014, which is defined as a company that's formed and registered in Ireland. But Article 3 of the European Insolvency Regulations confer on the Irish courts jurisdiction to open main insolvency proceedings in respect of a debtor with its COMI, its centre of main interest, in Ireland, regardless of its placing of incorporation. And the High Court, in its judgment delivered in July of 2023, confirmed that the part of Irish company law which I suppose governs the framework of examinership was subject to the EU Insolvency Regulation, and therefore part of Irish law by virtue of the doctrine of direct effect. And so the court found that where a company has its COMI in Ireland, the Irish courts have jurisdiction to place the company into examinership, even where that company might be incorporated outside of Ireland and the EU. And in that case, the court was satisfied that Mac Interiors had its COMI in Ireland, owing to several factors. For example, its tax residency was in Ireland, its administrative and marketing headquarters were based in Dublin, and in fact, all I think Mac Interiors employees were resident in Ireland. So secondly, just an Irish incorporated company with its COMI outside the EU. Now, as I've noted, if it's incorporated in Ireland, it comes within the definition of company for the purposes of Irish company law, regardless whether its COMI might be outside the EU. I suppose it does bear mentioning that if it's an Irish incorporated company but its COMI is in another EU member state, then under the European Insolvency Regulations, the main insolvency proceeding should be opened in that other EU member state. There's a presumption that a debtor's COMI is where its registered office is, but as with every presumption, that is rebuttable. And thirdly, I suppose a question is whether the same tests or requirements apply when the Irish courts have to consider whether to place a related company into examinership in Ireland, and the answer to that is no. A related company can be placed into examinership, as I mentioned, if it does not have its COMI registered office in Ireland or in any other EU member state for that matter, as long as it has a sufficient connection to Ireland. And that was considered in some detail in the Norwegian Air Examinership. Now that examinership actually commenced in December 2020, so before the end of the Brexit transition period. And a complexity to that was that the original petitioning companies were Irish companies with their COMI in Ireland, so no jurisdictional issue there. However, for the restructuring to be effective, the Irish company's Norwegian parent, which was Norwegian Air Shuttle ASA or NAS, whose COMI was in Norway, was required to be placed under protection of the Irish courts as a related company. And the Irish High Court found that the court's jurisdiction to appoint an examiner extended to a non-Irish debtor company that didn't have its COMI in Ireland or any other EU member state, but where the related company had a sufficient connection to Ireland. And again, on the facts of that case, the court was satisfied that NAS did, in what was referred to in the judgment as having a real and deep connection to Ireland because of its substantial direct and indirect Irish subsidiaries. And those Irish subsidiaries included an operating airline, a corporate structure to which its aircraft were owned and leased. One of the Irish subsidiaries held the group's intellectual property, and in fact, the Irish subsidiaries, their liabilities were guaranteed by NAS. So moving to what companies can enter into an Irish scheme of arrangement with its members or creditors. Can be an Irish incorporated companies, so again, nothing controversial there, or a company that has a sufficient connection or nexus with Ireland. So essentially it's the same test as we looked at in the previous slide in relation to related companies in the context of examinership. So because the European insolvency regulation doesn't apply to Irish schemes of arrangement, there's no need to satisfy the higher test of establishing COMI in Ireland. Now it's possible to establish sufficient connection with Ireland by changing the governing law or jurisdiction clauses, or both of, say, the appropriate finance documents. This issue was considered in the English case of Apcoa Parking Holdings from 2014, which then was later considered and endorsed by the Irish High Court in the Nordic Aviation Capital Scheme of Arrangement, which I'll discuss in more detail in the next slide. But I suppose the sufficient connection or nexus test in Ireland adopts the approach that's been taken by the English courts. So that's why I've set out on the table in this slide other examples of circumstances in which English courts have held that there was a sufficient connection to England to allow the English courts to sanction an English scheme of arrangement. And I suppose, while not necessarily binding on the Irish courts, as I'm sure many would be familiar, decisions of the English courts have persuasive effect in Ireland and get cited and relied on frequently. So when it comes to outward recognition of Irish schemes of arrangement in other jurisdictions, as I touched on, I suppose Irish schemes of arrangement can be used to restructure solvent companies. So a company can affect almost any kind of internal reorganization or merger or demerger using a scheme of arrangement if it obtains the necessary approval from its creditors or members. And I suppose the scheme just must be a genuine arrangement or compromise where the members or creditors of the company get some advantage or compensation for the scheme's alteration of their rights. So effectively there must be some element of kind of give and take, and it can be used to implement large and complex restructurings. An example being the scheme of arrangement of Nordic Aviation Capital in 2020. So NAC was the largest regional aircraft lessor in the world, certainly at that time. And the scheme resulted in a restructure of an excess, I think, of about $5 billion of debt owing to over 85 lenders on foot of about 90 separate finance facilities. And the court, Judge Barneville, its judgment from September 2020 found that an Irish scheme of arrangement falls within the definition of civil and commercial matters under the Brussels recast regulation. So I suppose at the time of the judgment in 2020, the Brussels recast applied in the UK, but it doesn't apply anymore for proceedings that have commenced after the Brexit transition period expired on the 1st of January 2021. And the court also held that it had jurisdiction to sanction the Irish scheme of arrangement under Brussels recast, where one or more of the scheme creditors were domiciled in Ireland, which was the case. And ultimately, the scheme has been recognised in at least 8 countries, which I have them listed in the slide. And the Irish court also found that with regard to, I suppose, English law governed debt, the English ruling Gibbs, which, as I'm sure many of today's audience will be familiar, but which effectively prevents debt obligations that are governed by English law being discharged by foreign proceedings without consent, did not impact the question of recognition. And I'll discuss the English ruling Gibbs, albeit in an examinership context, in my next slide. I just have lastly on this side, I've included the Barclays Bank Ireland case, and it's a recent and reasonably interesting example of a solvent reconstruction using an Irish scheme of arrangement, and it's a judgment of the Irish High Court from the 20th of December 2024, so quite recent. And in that case, Barclays Bank Ireland PLC, which was a subsidiary of Barclays PLC, had agreed to sell its German retail business, which had about 2.3 million customers, 4.6 billion euros deposits, and I think about 4.4 billion euros in loans to an entity called BAWAG PSK. BAWAG is an Austrian credit institution based out of Vienna, and the transaction was structured as an Irish scheme of arrangement, basically to hive down the German consumer business of Barclays Bank Ireland into a new co, followed by a cross-border merger of NewCo into BAWAG. And the reason it was done this way was to avoid the need for the NewCo to having to obtain a banking license, which would have been a very protracted and expensive process. And so the parties had obtained an exemption from the European Central Bank that would allow the NewCo hold the assets of the target for essentially a legal minute before merging with BAWAG. And I've mentioned it today because helpfully the Irish High Court gave a comprehensive written judgment running to some 237 paragraphs on the current law of Irish schemes. And the judgment covers the law on many aspects of Irish Part 9 schemes. But just in terms of the question of recognition of Irish schemes of arrangement, the court reaffirmed the position, I suppose, adopted in the Nordic aviation scheme, that the scheme proceedings were civil and commercial proceedings within the scope of Brussels recast. Because most of the Barclays Bank Ireland customers were domiciled in Germany, and their contracts therefore governed by German law, there were also kind of a small number of affected counterparties that were domiciled in Austria and the Netherlands and Luxembourg. But I suppose the Irish court had to be satisfied that if it made an order sanctioning the Irish scheme, that it wouldn't be acting in vain. So similar to the Nordic aviation case, the Irish court relied on opinions from local council in each of the various jurisdictions that an order of the Irish High Court sanctioning the scheme should be recognised and enforceable in their jurisdictions, and specifically the contracts could be universally transferred and evaded without the need of the individual customer or counterparty consents, which, given the fact that there were 2.3 million of them, would have obviously been a serious logistical undertaking. And as I mentioned a little earlier, English schemes of arrangement issued after the Brexit transition period no longer benefit from the provisions of Brussels recast. But Irish schemes of arrangement, on the other hand, should be entitled to automatic recognition under Brussels recast. So when it comes to Irish or any other European member state country for that matter, when it comes to their insolvency proceedings being recognised and enforced in the UK, in effect, there's just been a resetting, or it's as you were prior to the European Insolvency Regulation, which came into force in 2002. Now, recognition, I suppose, of the various EU member states' insolvency proceedings in the UK, recognition is now based on other, I suppose, more limited sources of recognition. And for most EU member states, that would probably typically be the UK's cross-border insolvency regulations of 2006, which implements the UNCITRAL model law on cross-border insolvency. And I think, if I'm right in understanding, that now requires a court application and is subject to the English rule in Gibbs. Just for the benefit of anyone who may not be familiar with the English rule in Gibbs, it's a rule, I think that's about 130 years old at this stage, but still good law, a decision of the English Court of Appeal. And what it says is that a discharge or compromise of contractual liabilities are governed by the proper law of the contract. So therefore, only English courts to be in a position to discharge or compromise English law governed debt, subject to certain limited exceptions. I suppose the rationale being that the rule it gives promotes certainty, allows parties contracting under English law to know that they will not have those obligations varied or compromised or discharged as a result of a foreign process, unless they voluntarily submit to that procedure. But I suppose the impact of the rule is far-reaching, because English law governing contracts continue to be one of the primary choices of law in international contracts, and specifically in a European context. But in terms of recognition of Irish insolvency proceedings in the UK, there is, however, a route that is only available to the Irish courts in relation to Irish insolvencies or restructuring of insolvent entities that's not available to other EU member states, EU member state courts or processes. And that's the provision I have on the slide of section 426 of the Insolvency Act of 1986, which says that a court of a relevant country or territory, and the process is contained in insolvency law, that the courts can issue a letter of request to the English courts for assistance to the relevant foreign court. And helpfully, Ireland is the only relevant country in the EU by virtue of the fact that we were in the Commonwealth up until 1949. But also importantly is that in granting assistance requests under section 46, I think subsection 5, the English court may apply the law of the other jurisdiction, or obviously English law when granting assistance to the relevant foreign court. And we have a reasonably recent example of an application from the Irish courts to the English courts for assistance, which is that Silver Pale Dairy case, which I've noted on the slide. And Silver Pale Dairy was Ireland's largest ice cream maker, which went into examinership in December 2022. And in March 2023, the High Court in the Irish High Court confirmed the examinership plan that was proposed by KPMG, or the Irish Examiner. But the company had creditors and supply to parties in the UK. So in order to ensure that all such parties were bound by the cram down affected by the Irish Examiner's restructuring plan, the orders of the Court of England were requested. So I think there was about 19 English creditors, 80% of which I think the debt was owed to HMRC. So the UK court, Judge Roth, granted the letter of request for assistance. I suppose what's of particular interest is that the effect of the English court agreeing to the request was that the English court was effectively applying Irish law to the English law claims, because the English court was asked to make an examinership scheme binding upon English creditors. And strictly, there's no provision of English law by which this could be done. So the English court was applying Irish law to the English creditors without finding the need to resolve the question of whether Irish law corresponded to any provision made under English law. Now, I would just say that there has been some debate and commentary as to whether the granting of requests for assistance by the English court in the Silver Pale case kind of amounts to a silver bullet for Irish restructuring proceedings and can sidestep the ruling Gibbs. It's probably not that clear cut. I'm aware that the English Supreme Court in other cases has probably gone so far as to say that the ruling Gibbs is so entrenched in English law that any decision to overturn it lies with not with the Supreme Court, but possibly with Parliament. So for that reason, I think what was an important factor was that the silver pale application was conducted on an urgent basis and was unopposed. So this procedure may accordingly be open to challenge in subsequent cases. And the last thing I just want to speak about today, when considering strategy and jurisdictional options in Ireland, is in relation to judgments that might be obtained outside of the EU, but where there might be assets in Ireland, or even assets elsewhere, but owned by an Irish subsidiary of the principal judgment debtor. And it's a case from 2023. So our client was an international aircraft lessor headquartered in Asia that had obtained judgment in the Southern District of New York in excess of $400 million against a Dutch debtor within a Russian group of companies, and the US judgment was obtained arising from repatriation of aircraft to Russia in breach of grounding orders and obligations following the imposition of sanctions after the Russian invasion. And the New York judgment had been obtained against the Dutch company because it had guaranteed the lease obligations, but the bank accounts of the Dutch judgment debtor were already subject to attachment orders by other airlines in unrelated proceedings. However, the judgment debtor owned an Irish holding company, which in turn owned a number of Irish SPVs that owned aircraft and engines, in a reasonably typical aviation structure, and at least some of the assets were unencumbered, and the aircraft and engines were in turn located in the UK and parts of Europe and also in the US. So I suppose the typical route to enforcement that you'd expect, because the debtor was a Dutch company, would look to have the US judgment against it recognized in the Netherlands, which in turn could probably be recognized throughout the EU, including Ireland, under probably under the Brussels recast. And supposed to give effect to the judgment, you might also then look as a next step for ancillary orders in aid of that judgment in the local jurisdictions to freeze and then enforce or execute against available assets. But I suppose, of course, that increases the risk that assets will be dissipated in the intervening period. So that's why in our case, we relied on authority in an Irish Court of Appeal decision from 2018 in a case called Albania Beg versus Ebelpower as grounding our jurisdiction to bring an application to issue the proceedings in Ireland and then serve outside of the jurisdiction, i.e. on the judgment debtor in the Netherlands, instead of having to bring the proceedings in the Netherlands first. And in the original Albania Beg case, the plaintiff was an Albanian company applying to enforce a judgment of an Albanian court, so outside of the EU, in Ireland against Italian defendants. And leave to issue and serve was at the first instance granted by the High Court. However, that decision was actually set aside by the Court of Appeal because the Court of Appeal determined that there was no direct or prospective benefit from enforcing the foreign judgment in Ireland, where the Italian defendant, had no assets in Ireland. I suppose the applicant in the original Albania Beg case failed to satisfy the court that there was a useful purpose in granting leave to issue and serve the proceedings in Ireland. And the three-part test identified by the Court of Appeal in Albania Beg are, as I've set out on the slide, and which we had to establish and satisfy the court whether we could firstly establish a good arguable case, and we submitted that the unsatisfied New York judgment established that fact. Was our client likely to obtain practical benefit from the proceedings? So in contrast to Albania Beg, in our case, the judgment debtor did have assets, via its subsidiaries, and a valuable shareholding in an Irish holdco, which in turn owned further Irish subsidiaries, which held assets of value. And lastly, could we satisfy the comparative cost and convenience requirements? We argued successfully that the Dutch judgment debtor was, part of a complex global corporate structure, and that it couldn't really be said that requiring the judge to defend proceedings in Ireland imposed a significant inconvenience on it. That there was little. We argued also that there was little point in commencing the proceedings in the first instance in the Netherlands, given that substantially its assets there were already the subject of attachment orders in unrelated proceedings, and also that there were assets in Ireland that appeared to be available to meet the process of execution here. Ultimately, I suppose we were able to persuade the Irish High Court that overall Ireland was a forum conveniens. And then, having got leave to issue the proceedings in Ireland at interlocutory stage, we obtained worldwide freezing orders and the appointment of a receiver over the judgment debtor shares in the Irish holding company to prevent dissipation of assets in the first instance. And then within 2 months of initiating the proceedings, we also obtained judgment in the Irish Commercial Court for the same amount as the New York judgment, and an order confirming the appointment of the receiver over the shares. So I suppose the case maybe also serves as a good example of how efficient the Commercial Court in Ireland can be. And it's the first time that I think I'm certainly aware of that an Irish court has appointed a receiver over shares in aid of a non-EU judgment against a non-Irish debtor. So that's all from me, and I appreciate that this has been something of a whistle-stop tour. I really hope it just gives today's audience kind of just some food for thought when considering strategy in Ireland as a jurisdiction for restructuring or enforcement, and the benefits of issuing those proceedings that Ireland could have. So I'll now hand over to Niall.
Thanks very much, Jamie, and thank you to those for attending. It's a bit strange staring into the abyss and not knowing who's on the other side of the camera, but I am assured by the good people at Mondac that there are in fact people online. So thank you very much for attending. The first topic which I want to discuss is the restructuring officer regime in the Cayman Islands. We still refer to it as new, but it's approaching its 3rd birthday in August of this year. So the new, in inverted commas, restructuring officer regime came in August 2022. The statutory provisions allow a Cayman company to restructure under the supervision of a restructuring officer, and they provide for a stay on creditor action during the restructuring period. At that time, when the legislation was introduced, there was significant uncertainty affecting the global economy post-COVID, and the provisions were certainly welcomed in the Cayman Islands. But of course, restructuring as a concept itself is not a new one, but the statutory regime is intended to make the restructuring process more user-friendly. It is worth noting that pre-August 2022, the Cayman Court had the power to appoint light-touch provisional liquidators following the presentation of a winding up petition in respect of a company upon certain conditions being met. And it's also important to remember, especially as the case law has shown since the provisions came into effect, that remedy remains available, albeit in a slightly modified form, and that there are still, in fact, circumstances where it may be more appropriate for JPLs to be appointed rather than restructuring officer, and we will touch on that a little later on. The key features of the Cayman Islands restructuring regime are contained in sections 91A to 91J of the Companies Act. And they are that a company can seek the appointment of a restructuring officer on the grounds that, first, the company is or is likely to become unable to pay its debts, and secondly, that it intends to present a compromise or an arrangement to its creditors. Under the regime, directors are expressly permitted to present a petition to appoint restructuring officers without presenting a winding up petition and without shareholder approval and or an express power granted to the directors in the company's articles of association. Also, one of the key features of the new regime is that from the date of filing a petition to appoint restructuring officers until such time as that application is either dismissed or withdrawn, the relevant section provides that there's a worldwide stay on civil claims against the company, which is clearly intended to give the company breathing room to allow it to restructure. The scope of the moratorium under the new regime is much broader than the limited stay that was imposed once provisional liquidators were appointed. That is, rather than the date the application was made. So that's an important distinction there. And this specific provision was aimed at tackling the uncertainty during that period when a winding up petition was presented and the passage of time before the appointment of either JPLs or the winding up of the company by the order of the court. So the restructuring officer regime is a separate statutory process to the winding up regime, which avoids the stigma that might attach to the tag or wrapper of liquidation. It's generally thought that this is an improvement because, with the presentation of a winding up petition, there is a risk that creditors might be misled or might have cause for concern that doesn't actually exist. Applications for the appointment of a restructuring officer will normally be made on an inter partes basis, but the Act does contemplate the possibility of urgent applications to appoint interim restructuring officers on an ex parte or without notice basis pending the hearing of the petition. And it's also important to remember that the new regime has retained the pre-existing position for insolvency proceedings under Section 142 of the Cayman Islands Companies Act. And this provision allows secured creditors to enforce their security without regard to the court or to court-appointed restructuring officers. So that's an important feature to bear in mind for secured creditors. And dealing with the case law, in a case called Orient, in November 2022, the Grand Court ordered the first appointment of restructuring officers under the new regime. The circumstances of Orient were that two unsecured creditors filed a winding up petition following the issuance and expiry of statutory demands, which obviously hadn't been paid. Subsequently, the company itself presented a restructuring petition seeking the appointment of restructuring officers. The day before the hearing of the restructuring petition, the petitioning creditors also filed a winding up petition in Hong Kong, which was in breach of the automatic stay imposed by Section 91G of the Act, and in which they sought that the company be wound up on grounds of insolvency. The court, in dealing with the matter, dealt with the statutory construction of the moratorium as a preliminary matter. And in relation to the moratorium, the court commented that the statutory stay under 91G might be said to turbocharge the degree of protection filing a restructuring petition affords the company. So the material difference here between an application to appoint restructuring officers and that for the appointment of light touch JPLs for the purpose of restructuring is that moratorium. It was argued by the petitioning creditors that it was not permissible to present a petition for the appointment of ROs after a winding up petition had been filed, and that the stay did not have any effect on existing winding up proceedings. And the company responded by saying that there was nothing whatsoever in the statutory scheme that prevented a company from doing so, from filing its own petition. The court concluded that there was no prohibition on presenting a petition for the appointment of ROs after a creditor's winding up petition had been filed, and accordingly the benefit of the automatic moratorium which attaches to that filing. And the court, in its judgment, was quite critical of the fact that the petitioning creditors had breached the automatic stay. Now, in relation to the test itself for appointing restructuring officers, the key findings of the court were that the evidence of insolvency or likely insolvency must be credible. So that goes to the standard of the evidence that you present. It has to have some detail on it. There has to be some meat on the bones. The intention to present a restructuring proposal to creditors must be met by credible evidence and must have a reasonable prospect of success. And for reasons that I'll discuss in a later judgment, I think that point has more salience. The fact that a loosely formed, immature plan is presented will not be a good way of satisfying that particular limit of the test. And the court also found that the proposal has to or will potentially attract support of the majority of creditors. So the judgment in Orient also reinforced, which I think is important for practitioners, that many aspects of the case law in relation to the provisional liquidation regime, which predated and postdated the RO regime, will remain persuasive under the RO regime. We often see a crossover between the two regimes. Moving on to the decision of Aubit. This is a decision of the Grand Court from October 2023, in which the Grand Court refused the company's petition to appoint ROs. The case was about a company's petition to appoint ROs under the new regime on the grounds that it was insolvent and unable to pay its debts, and it intended to present a compromise or arrangement to its creditors. The petition appears to have been presented in a state of some weakness from my reading of the judgment for two reasons. The supporting evidence of the company's insolvency was in a poor condition. The evidence itself included various letters of support from stakeholders, a good number of which were from management affiliated parties, and it provided only very limited financial information about the company and its creditors. It also failed initially to refer to the fact that the company was involved in ongoing litigation in the United States. And the second aspect of perhaps why this petition fell down is that the restructuring proposal itself was unorthodox, and it was found to be unsatisfactory in that it contained two stages, the first of which was an asset and information gathering phase, which was essentially an investigation phase, and secondly, the more typical restructuring phase, but only once the information gathering phase had taken place. Now, it was conceded during the course of the hearing by the company that the approach was unusual, if not unique. But from the court's review of the case law, it importantly provided a list of principles to be taken into account regarding the appointment of ROs. Both limbs of the test had to be satisfied. It had to be, that is, evidence of insolvency and or likely insolvency and the intention to present a restructuring plan to creditors. The plan has to be realistic. It has to be genuine and bona fide. It's not necessary for a plan to have to be fully formed in the sense of being finalized. But as we saw in this case, a hypothetical or abstract plan won't be sufficient to satisfy that second limb of the test. And it's only when both limbs of the test have been satisfied does the court have the broad discretionary power to appoint ROs. And when it comes to exercising its discretion, the court will consider whether the restructuring is likely to be more beneficial to creditors than the winding up petition, whether there is a real prospect of the plan being effected for the benefit of all classes of creditors, and in all circumstances, whether it is in the best interest of creditors to try to achieve restructuring, all of this by reference to the evidence. So in Aubit, the court refused the relief sought and warned that the petitioner, should have all of their ducks in a row, and if the evidence is inadequate, a company cannot assume that if it pitches up on the first day of a hearing with inadequate evidence that it will obtain an adjournment in order for it to cure or improve its evidence. So it's a good reminder for practitioners that even though the plan doesn't have to be fully formed, it does have to have some meat on the bones. The court was also mindful and made some comment about the need to guard against potential abuse of the regime. And it signalled on behalf of the Grand Court, more generally speaking, that it would be vigilant when policing the scheme and alert to potential abuses. And in the event in relation to this company, the company was subsequently wound up on a creditor petition. The next case, a recent case, which also discusses the circumstances in which the court might view the appointment of light touch provisional liquidators for the purpose of restructuring to be more appropriate. Following the introduction of the RO regime, there was some uncertainty about when the court would consider it to be appropriate to appoint a provisional liquidator under the relevant section of the Act, that's section 104.3, which incorporated modified language. And the decision in Kinky, which was handed down in April 2024, confirmed that in certain circumstances, court-supervised restructuring using the light touch provisional liquidation process is more appropriate. So the court ordered the appointment of light touch JPLs under the revised provisional liquidation regime. This was the first time this had been done since the introduction of the RO regime. In Kinky, there was disagreement within the company's board of directors, so that the court, having heard the evidence, he held that it was unlikely that the appointment of an RO would be adequate to address the issues that the company was facing. And it was also accepted by the court that the provisional liquidation regime has certain advantages over the RO regime for reasons that there may be difficulties obtaining recognition in other jurisdictions of the appointment of a restructuring officer. And there may also be difficulties in obtaining assistance from foreign courts for the recognition of such an office holder. The court considered the differences between the old and new statutory requirement in section 104.3 of the Companies Act, and this is in relation to the appointment of JPLs. The court commented that the revised form of words in 104.3 was drafted in wide terms and provided substantial flexibility. Under the old regime, it was necessary to determine, firstly, that the company is or is likely to be unable to pay its debts, and that the company intends to present a compromise or arrangement to its creditors. Whereas the new wording is that the court may appoint a provisional liquidator if it considers it appropriate to do so. The former language was more prescriptive to the situations where JPLs could be appointed. Despite there being potentially an opportunity to address the interaction between the test for the appointment of JPLs and the appointment of ROs, and whether the new wording of 104.3 expands the circumstances in which the court would be willing to appoint provisional liquidators, the court declined that opportunity. And I think for reasons probably similar to those that Jamie described earlier, this was in the context of an unopposed hearing, so it didn't have the benefit of full argument from both sides. And as practitioners, it seems that courts are unwilling, rightly so, to make pronouncements of principle in cases that haven't had the opportunity of hearing what arguments might be made against it. Moving on to another case about the appointment of ROs, which is Re Oakwise Value Fund, SPC. This is a judgment of the Grand Court from October last year. Oakwise is a segregated portfolio company. I'll discuss SPCs in greater detail below. So Oakwise, the company, presented a winding up petition seeking the appointment of JPLs over all three of the company's segregated portfolios, two of which were solvent and one of which was of doubtful solvency. The company's application was met by objectors from creditors of one of the segregated portfolios. They had obtained a default judgment against the company in Hong Kong for alleged unpaid redemption proceeds. And that creditor had also applied for a garnishee over all three of the company's segregated portfolios' bank accounts, regardless of which of the segregated portfolios they had contracted with. And this was in breach of the segregation principle, which is set out in the Companies Act. And that is to say that a creditor can only have recourse to the SP's assets, which it has a contractual relationship, and they're not entitled to the assets of the other SPs. So in Oakwise, the creditor asserted, amongst other things, that the court had no statutory jurisdiction to appoint JPLs in circumstances where the only route to appoint court officers for restructuring purposes was by the restructuring officer regime. The court indicated that while the new RO regime did create a bespoke environment or bespoke jurisdiction for insolvent restructuring, it does run parallel to the winding up regime, which can only be accessed through the presentation of a winding up petition. And the court made comment as well that it's obvious that if a party wanted to appoint court officers to do the type of things that provisional liquidators usually do, on the grounds that the company is prima facie liable to be wound up, that it stands to reason that restructuring officers would not be appointed under a regime which is dedicated to restructuring alone. So further invigorating the previous and current jurisdiction which exists and which is sometimes attractive, that of the appointment of JPLs. The court declined to address whether the provisional liquidation regime under section 104.3 of the Act could be exercised for the sole purpose of pursuing an insolvent restructuring, with the directors continuing in place. And he suggested that the answer to that question would have to wait for a more suitable or appropriate case based on the context and the facts. And then very briefly, there was a recent decision from February this year which further expands the continuing development of jurisprudence in respect of the restructuring officer regime, and that's the case of Holt SPC. There is a previous judgment from Holt SPC, I think it's from February last year, which though it was unopposed in the Grand Court, it was the first instance of a restructuring officer being appointed over segregated portfolios. And the judgment from just a few weeks ago considered the principles that are to be applied for the remuneration of restructuring officers and for their discharge. And that decision itself provides useful guidance to practitioners about practical guidance about how they are to fulfill their roles and how they're to be paid. So moving to segregated portfolio companies in the Cayman Islands. So any Cayman Islands exempted company can be registered as a segregated portfolio company. An exempted company in Cayman is one that's primarily engaged in activities which are outside the Cayman Islands. Generally speaking, SPCs are recognized to provide a suitable vehicle for multi-class investments, structured finance, feeder funds, and captive insurance as a convenient alternative to group subsidiary companies and subsidiary structure. The SPC regime has the benefit that as a statutory regime under the Companies Act, it also binds non-consensual third parties and extends the concept of ring fencing to parties who would not otherwise be covered by contractual ring fencing. The general tenets of a segregated portfolio company are that the company, which remains a single legal entity, it can create segregated portfolios in which the assets and liabilities of each SP are ring-fenced from the assets and liabilities of each of the other SPs and from the general assets and liabilities of the company. General principle is that the creditors of an SP can only have recourse to that SP's assets or potentially to the company's general assets if the SP's assets are insufficient. When it comes to insolvency circumstances, Section 224 of the Companies Act provides for the appointment of receivers in respect of an SP's assets if its assets are or they're likely to be insufficient to pay its creditors. The receiver is then tasked with the orderly closing down of the SP and distributing its assets to those who are entitled to them. An application for the appointment of a receiver over an SP can be made by the company, its directors, any creditor of the SP, a holder of any shares in the SP, or in the case of a regulated SPC, the Cayman Islands Monetary Authority. And so it's worthwhile noting that an SPC, that is the company itself, can be wound up voluntarily or by order of the court. However, it's the company itself rather than any of the segregated portfolios over which the liquidator is appointed. So in that event, if a liquidator is appointed, he or she is obliged to observe the segregation principle during the course of the liquidation, meaning that they can only discharge claims from the relevant portfolio and they have no right to claim against the general assets of the company. Some of the recent jurisprudence in relation to segregated portfolio companies, again, this comes the same case that I referred to above, it's Oakwise, but it was an earlier decision from the Grand Court from May 2023. And in this decision, the court considered the principles concerning the appointment of receivers. I should say that Oakwise was the subject of a Court of Appeal judgment from 2024, and I'll describe the difference in broad outline between the court's two different approaches. In Oakwise, the Grand Court adopted the test for the appointment of a receiver as previously set out in another case called Obelisk, a 2021 case, and Green Asia 2022 case. In this case, the petitioner sought the appointment of a receiver over an SP of the company. So the principles around the appointment of a receiver were summarized by the lower court. If anybody's familiar with Mr. Justice Doyle, his judgments are brilliant because they do a full summary of all the case law, and it's a real go-to when you're trying to discern the principles that apply on any particular area. He was subject to some criticism from the Court of Appeal later, but I guess that's the hazard of being a first instance judge, and they tend not to be too sensitive about these things. But anyway, so the principles found by the lower court to apply are that the language of the Act provides for a balance sheet test, which speaks to an insufficiency of assets to meet liabilities rather than the traditional cash flow test. And a company is insolvent under the balance sheet test if its assets do not exceed its liabilities, taking into account its contingent and prospective liabilities. The application of the balance sheet test requires a determination on the available evidence of whether the assets are sufficient now or they're likely to be in the near future, held in a form that may be used to pay the claims of creditors. And in that case, the Grand Court wasn't satisfied that the evidence on the insolvency ground was enough. And even if the insolvency ground had been established, that the court wasn't satisfied that the making of a receivership order would be in the best interests of investors or creditors. The Court of Appeal overturned the Grand Court decision and granted the receivership application on the evidence, and it held that on the evidence available to it, the Grand Court should have held that the petitioner had established at least a prima facie case that the assets attributable to the SP were likely to be insufficient to discharge the claims of creditors, and that the company had failed to rebut the presumption that had arisen from that finding, and the assets attributable to the SP were likely to be insufficient to discharge the debt owed to the petitioner. And what that Court of Appeal judgment does, I think in very helpful terms, is that it brings further clarity to the test for the appointment of a receiver over a segregated portfolio, and it affirmed the flexible approach, flexible balance sheet approach. But it does highlight in quite a stark way the need for cogent and, if at all possible, independent valuation evidence when a party is trying to persuade the court that there are sufficient assets to satisfy a debt. That's all I propose to say about segregated portfolio companies. And there's one thing that I'll touch upon very briefly because I'm mindful of the time, and that is special purpose acquisition companies. And many of the people on the call will be familiar with these types of entities. For those who aren't, a SPAC is a structure whereby a special purpose vehicle is listed on a public stock exchange for the Cayman Islands, that's often New York, to raise IPO proceeds, which are then used to complete a merger with a privately held entity within a certain amount of time, usually 18 to 24 months. The concept isn't new, but appeared to experience a kind of a renewed surge of enthusiasm for it after the COVID pandemic. The structure generally means that Class A shares are issued to the public at a specified price. Those proceeds are held in trust, and if the time for consummation of the merger is exceeded, the proceeds have to be returned to the investors. That's the general structure. And in exchange for funding setup costs and acting as director or managers, the sponsors of a SPAC are issued Class B shares, which generally convert into 20% of the value of the SPAC if the merger is consummated, but are otherwise worthless if the merger doesn't take place. Though I haven't done the calculations, I've read that an estimation that approximately 1/3 of the SPACs launched globally post-pandemic, that's kind of 21 to 23, were incorporated in the Cayman Islands. And obviously, from our point of view, in the event that a merger isn't consummated, that this can give rise to claims against the SPAC itself. And typically we see the most common one that we see is creditor claims incurred by service providers who haven't been paid in full, and in particular lawyers' fees, which can be significant, especially when there's a US nexus. Next type of thing we see is investor claims, which where steps that were to be taken in accordance with the company's documents haven't been taken, and then claims by counterparties, including an entity with which a SPAC has failed to complete a merger. I see that the clock's gone to 0, so I won't say anything more about SPACs, but obviously if someone has anything they'd like to discuss, we'll be more than happy to discuss that offline. And likewise for any of the issues, we'll be more than happy to discuss those offline, or pick up the phone to you if you'd like to speak.
Absolutely, Niall. And I think that we have a final slide, Jamie, with everyone's contact information. Just looking at the time, we probably don't have too much time for questions. We just have one that I have for Jamie, but just before we move to that Q&A, I just want to say thank you very much to Niall and Jamie and to Dylan Eustace for your thoughts and insights today. It's been fantastic to spend an hour in your company this afternoon. So Jamie, I'll just put this question to you before we finish and get any closing comments. If the examiner has to report to court within 100 days, how long is the company typically under the protection of the court?
Well, typically once the report is filed, the court will try and convene a sanction hearing, usually within probably 2 or 3 weeks after the 100 days. At that hearing, at the sanction hearing, either the examiner's scheme will be confirmed, or if for some reason the court doesn't want to sanction the scheme, then because the company is almost entirely insolvent, then there'll be a very quick application probably to have the company put into liquidation. So probably typically you're looking at maybe at say 120 days would be probably a good average.
Excellent. Thank you very much, Jamie. And as we mentioned, if you do have any questions or thoughts that you want to share, please do get in touch with Niall and Jamie. As I say, thank you very much, Niall, Jamie, for your thoughts, insights today. It's been fantastic to have you, and also to our audience for being with us. We really appreciate it. So thank you very much, everyone, and I hope you have a lovely rest of your day.